Good evening and welcome from the League of Women Voters of Portland. I'm Carolyn Bubert, President. We're excited to bring you tonight's program. It's called Portland's New Community Board for Police Accountability, Progress and Next Steps. In November 2020, Portland voters overwhelmingly supported a ballot measure that will lead to the creation of a new police accountability system. In order to begin designing the system, City Council appointed a 20-member volunteer police accountability commission assigned to fill in the details and draft city code language for City Council's consideration. The commission accomplished their work a few weeks ago and submitted their report to the City Council. And it's now the Council's job to accept or modify the proposal and enact the police oversight system. So our program tonight is very timely. The panel for tonight's program will provide an overview of the proposal and detail the next steps. The League is dedicated to making democracy work. One of our core beliefs is that democracy functions best when voters are informed about issues and engaged in their communities. For these reasons, we present programs like this to give our Portland neighbors a chance to listen and learn and discuss about issues that are important to us all. After tonight, would you tell your friends, colleagues, and family that this program can be viewed on video or listened to on podcast, and the links will be available through our website, www.lwvpdx.org, in just a few days. Our moderator tonight is Monica Arce. Monica is one of the 20-member volunteer panelists for the Police Accountability Commission. I'm turning the program over to you, Monica.
Thank you, Carolyn. My name again is Monica Arce, and I use she, her pronouns. I was chosen to volunteer as a commissioner for the Police Accountability Commission in Portland. I represented organizations working with overpoliced communities, as well as a member of an overpoliced community. I am an immigrant, a mom, a Portland resident, and a midwife and site medical director at the Virginia Garcia Reproductive Health Clinic in Hillsboro, Oregon. It's my pleasure to introduce our esteemed panel, who will discuss the basic elements of the new system, the transition plan, and next steps leading up to when the new agency begins accepting complaints. First, I want to review the main provisions included in the charter amendment that Portland voters approved with an 82% majority in November 2020. Since these concepts are now in Portland's charter, changes to these basic provisions can only be made by another vote of the people. According to the voter-enacted charter amendment, members of the new Volunteer Police Oversight Board will be appointed by City Council. Responsibilities of the board are as follows: selecting and hiring the director, who will hire and manage the administrative staff and the investigators. Agency staff will investigate complaints of possible police misconduct, including deadly force cases, and will have subpoena power and the power to compel testimony. The board will have the authority to impose disciplinary actions, including terminations. Officers and complainants will have the right to appeal the board's decisions. The board will be able to make policy recommendations to the police bureau. If the bureau does not accept the recommendations, City Council will make the final decision. And the equivalent of no less than 5% of the police bureau budget will cover the system's cost. Now I'd like to turn to our panel members. We have 3 panelists who served on the Police Accountability Commission with us tonight: Yume Delegato, Dan Hendelman, and Faith Aiken. Jared Hager, trial attorney with the Department of Justice Civil Rights Division, will explain next steps and the Department of Justice and court's role. After the presentation part of the program, I'll pose audience questions to our panel. You are invited to put questions into the chat, either to individual presenters or in general at any time. Our first panelist, Yume Delegato, will explain how the new board will be selected, its powers and duties, and provide information on the agency staff. Thank you, Yume. Oh, sorry. Go ahead, Yume.
Thanks, Monica. It's a pleasure to be here. My name is Yume Delgado. As Monica mentioned, we were fellow commissioners on the Police Accountability Commission. And with regards to board membership, I think this is one of the areas where the city charter is, I think, most explicit about some of the things that people have questions about, in that it clearly outlines that board membership will be limited to people who meet the typical city standards of living, working, playing, worshiping, or otherwise doing business within the city of Portland, and that no current or former law enforcement employees or immediate family members of current employees will serve on the board. In addition to this, the board has 33 volunteers that will serve staggered 3-year terms. So that first group of board members will include 11 people serving for 1 year, 11 people serving for 2 years, 11 people serving for 3 years. The board will also include modest compensation for the time served on the board based on caseload and member support for things such as childcare or mental health services. This is intended not to be the primary source of income for board members, but a way of removing barriers as outlined in the charter for participation. So it's envisioned that this board will require significant time commitment. And so having modest compensation along the lines of what other agencies throughout the country do is a very good way to allow people to do that work. Okay. They estimate that the sort of median compensation for volunteers will probably not exceed about $5,400 a year. Another feature of the board is that while there will be 33 members, most cases will be heard by a panel of 5 to 7 panelists for an individual case or appeal. So it's really almost more of a pool of committee members than a board that's going to be hearing a case with 33 people, on that case. Comparing this to the current system, the Citizen Review Committee has 11 members, and the civilian pool of police review board volunteers has 15 members for a total of 26. So when you look at the current structure versus the proposed structure, there is a certain degree of similarity there. Moving on to powers and duties, again, as outlined in the charter, the new board will have the capacity to compel testimony and subpoena documents as necessary. Ideally without the use of a subpoena, but they have that power available to them. The board will also be the direct deciders of findings and discipline rather than making that recommendation to the mayor or to the chief of police. So in the current system, CRC panelists or police review board panelists are often required to use what's called a reasonable person or a reasonable unit manager standard of review. And then if they make a determination, they are really only making a recommended finding. They are not actually making a final determination. So the new board will be directly deciding those cases, and they'll directly be determining discipline. The new board also has the capacity to make policy recommendations directly to the Bureau and to the chief. And if the chief chooses not to enact those recommendations, they can forward those recommendations on to council. And again, council must make a decision either affirmatively or in the negative. Moving on to agency staff. One of the, I think, most notable features of this new system is that the staff will be sort of a one-stop shop. There will be one bureau. It's an independent bureau from Portland Police or any other agency at the city that will handle all complaints, at least all complaints involving community members. The board will select the director of that agency, and then the director will select staff or will hire staff. Staff will include investigators, data analysts, and also a complaint navigator, which will assist the complainant throughout the entirety of that process. And Dan will speak to that a little bit in the next section. That board staff will, as determined by the PAC, not include any former police officers, although people with ancillary roles, can apply for employment with this new board. So that covers, I think, the board membership, some of the powers and duties that they have, and agency staff. And I think I'll turn it back over to Monica to introduce our next speaker. Thank you.
Thank you, Yume, for that overview. Dan Handelman, please go ahead with your presentation on how complaints will be processed and officers held accountable by the new system.
Well, thank you very much. I'm glad to be back with you all. We used to spend two evenings a week with each other. We haven't seen each other for a while. I'm Dan Handelman. I use he, him pronouns. I'm a member of the group Portland Cop Watch, as well as a former member of the PAC. Portland Cop Watch was formed in 1992, and one of our three main goals is to advocate for a effective oversight system for the police. So I participated in the 2000 Mayor's Work Group that helped transition the original oversight system, which was known as the PIIAC, into what's the Independent Police Review, the current system. And I'm glad that I was able to be part of the PAC to help design this new system. I've attended almost every oversight board meeting in the city since 1992. I'm going to talk about how a complaint or a case moves through the system, and regardless of whether a complaint is filed, certain incidents will lead to investigations, like deadly force cases. They'll automatically open up a case about that. Some of this is spelled out in the charter, and other aspects are spelled out in the code that we designed. I'm going to use a flow chart that was part of the PAC's final report to walk through the steps, but bear in mind, this is going to look really complicated, but the current system is even more complicated, and Yume was just kind of referring to that. So it involves moving a community member among these four systems: the Independent Police Review, the Police Internal Affairs Bureau Division, the Citizen Review Committee, and sometimes the Police Review Board. And then in some cases, the case can go all the way up to City Council. So there's as many as 5 different places it can bounce to, but this will all be within this one system. The main thing we were trying to do when we're designing this was to level the playing field as much as possible. The current processes and the laws favor the police. Only about 10% of the complaints right now result in an officer being found out of policy. Officers have access to advocates through their collective bargaining unit, and they have as many as 4 ways to appeal, which we couldn't change really. We added the role of a complaint navigator so the member of the public can get support from the start to the end. And the proposal that we wrote calls for the navigators to come from diverse backgrounds and to be trained in a way that can respond to the specific cultural needs of the complainant. I think that's really going to make a big difference. Okay, so here's the flow chart that I was talking about. I'm going to pull that up now. And of course, it's scrolled down to the bottom. So here's the flow chart, and we're going to start here at the top in the intake section. After the incident happens, the complainant or survivor is going to be assigned, as I said, a complaint navigator. Again, one of the most important aspects of the new system. There are 4 things that could happen during this intake phase. That's where there's 4 arrows. The complaint might be dismissed. The complainant can appeal that, and that's something that doesn't exist now. So that was something the PAC added. 2, we were told by that many people who contact the current IPR system don't want to punish the officers, they just want to talk to the supervisor. So that is an option as long as it meets certain board criteria and if the supervisor agrees to it. Then we also have an option for mediation that allows the complainant to talk one-on-one with an officer in a confidential setting. This has existed in Portland since the early 1990s, and the PAC felt strongly it should continue to be and also to be enhanced. The discussion and the specific outcomes of the mediation are generally not going to be revealed to the public, but it can be if both parties agree. And the 4th option is that the case will undergo a full investigation. So that's here, we're in investigations now. If there's a possibility that the officer committed a crime, a parallel criminal investigation will take place. That happens now, particularly with deadly force cases. If the investigators find some reason that they want to dismiss the case while they're doing the full investigation, they can do that, but the community member has another chance to appeal, which again doesn't exist right now. Once it gets the investigation gets completed, then we move on to the next phase, which is hearing and findings phase. A preliminary hearing gets held to make sure that the panel that Yume was talking about, the panel of 5 or more board members, will determine whether or not there's enough information to go ahead with the hearing. And then once there is enough information, they will hold a full hearing. The allegations against the officers are generally found either in policy, that's over here, or in policies over here, and out of policies over here. And there are other findings I'll discuss if I have time. If one or more findings are not substantiated, that is to say that they were found in policy or one of the other non-sustained findings, the complainant can appeal those findings, and we'll talk about that a little bit. There's findings that officers violated policy. The board makes a preliminary recommendation of what corrective action or discipline might happen, and then the officer can appeal that, and that's something that's missing from this version of the flow chart. They can appeal the findings. They can also ask for a due process hearing, which is something that is guaranteed by Supreme Court decisions about public employees, and we can't take that away. So they can go have a due process hearing. In our design, it's going to go back to the same panel again for them, the officer, to explain their point of view if they felt they weren't heard properly before. Or they can stipulate or agree to the findings in the discipline and waive their rights to appeal. Okay, and I'll talk about that other bubble a little later. So then after this is all done and the panel has decided on a course of corrective action and discipline, they will make a finding that either the officer will accept it, or they can, again, they have a couple avenues of appeal after that, where they can go to the Civil Service Board that's written into the charter of the city, or they can initiate a grievance, which could end up in an arbitration if the grievance doesn't resolve out of that arbitration process. You've probably heard about that happening in real life in the current system. And again, we can't take those away. Those are guaranteed rights for employees. Right, then the final section that we have here is the appeal, and the appeal, would basically probably come before the corrective action if there's community member appeals. So there's three possible things that could happen. The panel could agree with the original findings. The panel could send it back for more investigation, and then that will either lead to the same findings, or the panel can make new findings, and if there are new substantiated findings, it'll go back up here to the hearings and findings, to the corrective action and discipline phase. All right, so that's the gist of how something goes through the system. I see I have a couple of minutes left, so I'm going to talk about exactly what the findings are. There are 4 possible findings in the Portland's current system, and we are maintaining them in the PAC. We're just changing the names. It's pretty standard nationally to have these 4 findings. I mentioned the broad categories of in policy and out of policy. I hope those are pretty clear. There also may not be enough evidence to prove or disprove an allegation, which leads to a finding of insufficient evidence. And if the facts that show the incident did not happen the way they were alleged, the finding will be unfounded. And then I forgot to, well, I mentioned that there's a bubble up in the middle of the flowchart about systemic findings. And there was a formal consultant that did a formal consultant's review done of the IPR system, the current system, in 2008. And that led to a stakeholder group in 2010 that I also sat on. And since then, people who were on there, people in the community, have been echoing that consultant's call for there to be systemic findings added in misconduct cases. So, for example, if the officer followed policy, but the policy is inadequate, the board can make a policy issues finding and recommend that the policy be changed. And similar findings will be able to be made about how supervisors' involvement led to the outcome and whether there are issues with training, communication, or equipment. And none of these are going to lead to discipline for specific officers, but it can help improve the Bureau in the future. All right, well, I hope that's all as clear as mud. I appreciate you listening, and thanks for your time. Turn it back to Monica.
Thank you, Dan, for your informative remarks. Next up, we have Faith Aiken. She'll describe the PAC's proposed transition plan. She'll also explain briefly how the new board and agency will report to the community on its activities. Faith.
Thanks, Monica. Hi, good evening. My name is Faith Aiken. I use she, her pronouns. I am a former commissioner of the Police Accountability Commission. I came to the commission with an interest in having disabled perspectives as part of the conversation. I'm a person with a disability and have long been part of disability justice conversations in Portland. And so, as Monica mentioned tonight, I'm going to be talking about some of the reporting or the data visibility that the PAC recommended, along with the transition. So how do we get from our current system into what we have recommended? I think it's important to note that we have been given 30 minutes to cover 18 months worth of work and a 503-page report. So if it seems confusing or that we're moving quickly, we absolutely are. We're excited to get into Q&A with you to be able to talk about this a little bit deeper, but we are going very, very high level on some really detailed, weighty topics. So I'm going to start first with the reporting. So one of the things that we did in the very beginning of the PAC's work was we talked about some of the barriers and best practices that are in the current system in Portland. And one of the best practices that were mentioned was the way that IPR, the Independent Police Review, displays their data. They have dashboards available online. I'm going to just show those right now in case you've not seen them before, but they are available here on portland.gov/IPR/IPR-data. So you can look at these through Tableau, and I'm just going to make this bigger so you can see it. So you can see a summary of complaints, and then you can look at it by disaggregate it by year or by zip code. You can see a heat map. You can disaggregate by race. But one of the things that is not available through this dashboard is, you can see here, here's a little Tableau secret for you, is if you click here, you can download oftentimes the background data. And you see here that it's grayed out. And so this is one thing that felt very important for us in the recommendation, is we want to be able to display data through these dashboards, but we know that there are a lot of analysts out there, or folks who like to crunch numbers like myself, who want to be able to pull the background data. And so when you have Tableau dashboards like this, I always encourage folks to click this little download button and see how you can download it. And hopefully you'll be able to download it by data. And so that's one of the things that we've recommended to be included in the new oversight body. So another thing that we recommended was a yearly annual report. On our recommendations, you'll be able to find all of the ways we want to see the data disaggregated, but of course we will leave that up to the new board and their staff to work through. So the second thing I'm going to be chatting about today is the transition plan. So how do we get there? So as my colleagues remarked, we are currently in the middle of a pretty complex system. Let me get this full screen. In a pretty complex system. And so how do we get from where we are now to where we want to be? And so I'm going to go over very quickly kind of a timeline to get us from here to there. And some of these dates you'll see are written as set. So that's a determined amount of time or an estimated amount of time. And I'm going to go through this and talk about what the transition looks like to get there. So right now, you'll see that we're right here, and I'm sorry it's a little bit blurry, but you'll see we're right here, September 1st through October 30th. So the PAC had until September 1st to present their final recommendations and their code package. So the PAC did that on September 21st. We handed everything over on September 1st, and City Council has a set 60 days. So they have until the end of this month to take the PAC's recommendations and our code package and then present it to the U.S. Department of Justice for court review. So within those 60 days, we sent them our highest and best. And there are provisions that are unchangeable, as my colleagues have mentioned, outlined in the charter. And then there were details for us to flesh out. And so City Council has the opportunity to make any changes to then pass it to the U.S. Department of Justice. So I was just speaking through on the left-hand side, A1A, Council Initial Review, which is all smushied, our 60 days. And then speaking to this middle section, which Jared Hager will talk a little bit about what's going to happen with the DOJ review, but you can see the text above. So these are the recommendations that the PAC made to happen during this time period. So while the DOJ is reviewing what City Council has put forward, the PAC has made some recommendations around selecting a transition team. So you may mentioned our board membership in a future office or bureau. And so the transition team is really needed to get that work going. So the transition team would work to develop a set of draft bylaws based on the PAC's bylaws, would work on initiating any changes needed in the collective bargaining agreement with the Portland Police Association, and then would develop the application for new board members at this time. So that would happen. Again, we don't know how long the DOJ review will go, but this outlined in the text would happen during this estimated 6 to 7 months. So let's assume that the DOJ accepts everything that council put forward. Then there is a set 21 days for council to then review what the DOJ has brought back. Council has 21 days to finalize the PAC code change recommendations. Collective bargaining would be concluded and other legal requirements would be satisfied. So we are, just for the sake of an argument, we put these dates in here for us to understand, and we're calling this a pre-transition phase. So where we are right now is we are in this far left-hand side of a pre-transition phase to get us to final okay at the end of the set 21 days. So what is in purple is a formal transition phase. So once City Council has given a stamp on the 21 days, then officially the new board can begin and the office will be open. So the oversight board officially exists on day 1. And the transition team, as mentioned in the previous slide, manages the recruitment of the board and submits vetted candidate applications with recommendations to City Council. And City Council appoints the new 33-member board. The new board is, as you may have mentioned, in charge of hiring the new director. So they would be working to draft a job description and look at what the recruitment process looks like for the first director. With support from the transition teams, moving on, we would be hiring the director and developing training. The transition team would be training new board members and the first director. Peer training would be done by former CRC members and civilian members of the Police Review Board. So after that, we have a new director on board, and the new director would prioritize hiring key staff. So investigators, a complaint navigator, as my colleagues have mentioned, and then potentially legal staff. From there, you can see in this final purple column, A2D, training and preparation for case intake and investigations. So the director would oversee the staff training, and training may be delivered by the transition team and experts or affected parties. The 4 bodies that Dan mentioned, IPR, CRC, IA, and PRB, I'm sorry that I'm using so many acronyms, would transfer their information and all of their data related to past cases to the new office and to the new board at this time. So this is a set 1 year, 365 days. So we're calling this the post-transition phase. So the estimated, based on all of these estimated dates, we're saying is July 1, 2025. And in the first 6 months of the post-transition phase, any new cases would be taken by the new board. So intake of new cases on day 1 would go directly to the new board in the system outlined by my colleagues. But at that time, internal affairs and IPR will continue to resolve the complaints that they were currently reviewing. So they will have 6 months to do this. CRC will also continue to hear appeals and work to resolve all pending appeals, to be done by the end of those 6 months. The phase 2, so the second 6 months in this post-transition phase would be kind of the beginning of the end of all of the transition. So no other bureau will continue their work on investigations of police misconduct. Any other ongoing work will be transferred to the new Oversight Board and Bureau. And that will get us to July 1 of 2026. So hopefully in 2026, July, we would have a completely new board and staff up and running with all of the pending cases closed. I think that I did it within my time, Monica.
sure did.
I'll pass it back to you.
You sure did. Thank you, Faith, for sharing the transition plan with us. That's complicated stuff. Finally, trial attorney Jared Hager will discuss the U.S. Department of Justice's role in evaluating City Council's proposed settlement agreement amendments, how the process will go forward from here, and when we can expect the new oversight system to begin accepting complaints.
Thank you, Monica, and thanks to the League for having me and putting on this educational event. My name is Jared Hager. I'm a trial attorney with the Special Litigation Section of the DOJ Civil Rights Division. I'm in the Police Practices Group and have worked on systemic police reform cases since 2015. Although I work out of DC, I am a Portland resident and I live in the Park Road neighborhood. And I've been working on the Portland Police settlement agreement with the DOJ since 2015 as well. There's a lot of local process that's been talked about. So why are the federal government here talking at this event? Well, we do have an ongoing matter with the city of Portland and the Portland Police Bureau. And I want to give a little bit of background about that matter. And then I'll segue into hopefully not treading on too much of what Faith just talked about, but I do want to give the perspective of the federal government and the court's role in this process going forward. So by way of background, on June 6th, 2011, it's been quite some time, DOJ opened an investigation of the Portland Police Bureau under 34 USC 12601. Now that's what we call the police misconduct statute. It's a law that was passed in the wake of Los Angeles Police Department's beating of Rodney King that was caught on film. And that law authorizes the U.S. Attorney General to obtain injunctive relief, that's forward-looking remedies, to address systemic violations of federal law by state or local law enforcement agencies. DOJ released our findings of the investigation on September 13th, 2012. We concluded that there was reasonable cause to believe that PPB engaged in a pattern or practice of violating the Fourth Amendment by engaging in excessive force as it relates to people in mental health crisis or people with mental illness or perceived to have mental illness. And one of the root causes that our investigation found of that pattern or practice of misconduct was insufficient systems of supervision and oversight. After we issued those findings publicly, and you can find them online at the DOJ's website or on various on the City of Portland's website, the city, PPB, and DOJ then negotiated a settlement agreement to resolve DOJ's concerns. On December 17th, 2012, DOJ and the city filed together an agreement with the Federal District Court for the District of Oregon. Judge Michael H. Simon has presided over the case since that time. In litigation that ensued, the Portland Police Association intervened. They are an intervener defendant in the litigation, and the court also granted enhanced amicus curiae status, friend of the court status, to the Albina Ministerial Alliance Coalition for Justice and Police Reform, which is a group of representatives of community organizations and churches in the Portland area. The court has also since granted a friend of the court status to the Mental Health Alliance. And I believe all of those groups had members on the Portland on the Police Accountability Commission. I don't know that the union was represented, but I know they presented. On July 30th, 2015, Judge Simon entered this settlement agreement as a court order. That makes this a little bit different than a normal contract. It's a contract that has the power of the federal court behind it. It acts as a consent decree, and the remedies within the settlement agreement, the things that the city and the police bureau promised to do, are enforceable by the federal court. The agreement provides for comprehensive reform of city and PPB policies, procedures, and training in use of force, in interactions with people with mental illness or in crisis, in areas of accountability and oversight. And essentially, the agreement covers 8 areas of substantive police reform: use of force, training, community-based mental health services, crisis intervention, an employee information system, officer accountability, which is important for this event, community engagement. And then as an 8th area, there are additional remedies arising from the city's response to protest in 2020. And so after 2020, the DOJ issued a notice of noncompliance, and we resolved that notice of noncompliance on February 25th, 2022, by adding 8 new remedies. Now, one of those remedies is to put body-worn cameras on officers who engage with the public. That is an important source of information, of data, to understand what happened during that event. But another of those 8 new remedies concerns this new community police oversight board. And it puts into the settlement agreement, it puts into this federal court order the ballot measure and the new oversight board to replace independent police review for investigations of complaints of police misconduct, and to replace the chief of police for imposition of discipline. The parties put all of this into paragraph 195. It's available online, or you can get it from any member of this presentation. And it has 4 basic parts. I'm going to focus on one of them, but I want to tell you about all 4. The first is a preamble, and it broadly says that in 2020, the city referred this ballot measure to the people to overhaul the police accountability system incorporated into the settlement agreement by establishing this new oversight board and broadly defining its duties to investigate misconduct and to impose discipline. The city then empowered the 20-member Police Accountability Commission to define the duties and authorities of the oversight board and to submit that proposal to city council for final approval. So that's the first part. The second part deals with the independent police review and ensuring that its function continues during the transition to operationalizing this oversight board. And the gist of it is that until the oversight board is operational, the city is obligated to ensure that administrative investigations, those are investigations of the police complying with their policies, the city's got to ensure that those are completed as required by the agreement. And again, Section 8 talks about accountability in the processes. And the third part of this paragraph is to set up it sets out the 6-step process from the PAC to the new oversight board. Now, Faith has talked about the first 2, and the first one is that 18 months from the date of the agreement, the PAC would have its ability to conduct its work. That work is now done. The second step is 60 days of receiving the commission proposal. The city is going to propose amendments to the code to address the proposal and also corresponding amendments to the settlement agreement to ensure full implementation of the oversight board and effective police accountability consistent with the requirements of the settlement agreement. Now that's a verbatim quote. Essentially, what's happening here is that the agreement did things like codify independent police review. Now, it's a federal court order. The city, in order to change from, needs to propose some amendments. And that's where the Department of Justice comes into play. We're not going to review and evaluate the amendments to city code. That's the city's business with based on the PAC's recommendation. But anything that changes the settlement agreement is going to be subject to the United States of America, our approval. And that's the DOJ's approval. And that process, I cannot put a date on it. It will depend on what types of changes City Council decides to propose. But we'll consider those in good faith and hopefully expeditiously, and it won't take more than a month or 2. I can't make promises, unfortunately. That's the third step, is the United States reviewing and approving the proposed amendments to the agreement the city council comes up with. There's a fourth step. Once the United States approves it, that doesn't make it a done deal. This agreement is a federal court order now. And so before the 21 days kicks in, the United States and the city, as parties to the settlement agreement, need to propose the amendments to the court. We need to file a motion to amend the agreement, and the court will consider that after holding a fairness hearing where the court will hear from all members of the public, and the court will evaluate if what the city and DOJ have proposed is, quote, fair, adequate, and reasonable. Now, that's the legal standard for the court to amend a consent decree like this. Again, we don't have a clear timeline on what that would take. Typically, the court likes there to be a 30-day waiting period before a motion and a fairness hearing. We've had the court approve amendments from the bench the day of the hearing. We've had the court take some time to think about it. I expect, depending on the nature of these amendments, it might go pretty quick. So after the court approves the changes to the settlement agreement to codify the new aspects of the oversight board into the settlement agreement, then the 21 days will kick in for the city council to consider and vote on the conforming city code provisions that will create the oversight board. There will have been a lot of time in between, so I don't expect that to be a tricky deadline to meet. I cannot speak for the city though. Final step. So within 12 months of the council's adoption of the city code provisions, the city needs to stand up the oversight board, staff it, make sure it's operational. And at that point, IPR can cease taking on new work and complete any pending work. And of course, that is subject to, the city council taking recommendations from PAC in terms of the transition process. Now, those deadlines are not all set in stone. While we say 60 days for the city council to propose stuff to DOJ, while we say 21 days from the approval of the amendments by the court for the city council to act, for good cause shown, and this is codified within the settlement agreement, the deadlines imposed by the settlement agreement can be reasonably extended, provided that the city is ensuring that IPR is continuing its work and that there has been effective accountability by ensuring that officers are held accountable for violating policy. So that is the process. One final aspect. This is the fourth aspect of paragraph 195, and it's an important one because I'm not quite clear where it fits in, but it's a collective bargaining provision. The city is obligated to comply with any collective bargaining obligations it may have related to the oversight board. Now, I don't know what those are. That's a question for the city and the union to hammer out, but I will say that both the city and the union had agreed to this amendment. So they've agreed to paragraph 195. And so they'll go forward with their collective bargaining and do that in good faith, as we know they do. But that is one overlay to all of it. And so with that, that is essentially my part of this process. As a member of the DOJ, as a local Portland resident, I am familiar with some of the issues and the longstanding history. And I do want to assure the public, assure the PAC, given their hard work, and assure my friends with the union and with the city attorney's office that we are approaching this with a measure of good faith to see what's going to happen. We do appreciate the city council is deliberating on this proposal. We also appreciate that the PAC put an enormous amount of work into coming up with the recommendations. And really, I look forward to seeing what's going to be proposed and moving this forward. I heard a date of 2026. These are back end dates. Hopefully it doesn't take that long, but ultimately there are some unknowns here and some uncertainties. So we will work through those. And I am always available to meet with any member of this call or anyone watching online to talk about how we're approaching things when we receive it. But at this time, I'm not authorized to speak to the PAC's recommendations. These recommendations are going to City Council. While I could consider City Council's proposal to us, that has not come to us yet. And so we're waiting to see what's going to be proposed. With that, I really do appreciate the opportunity to be a part of this conversation and look forward to effective police accountability going forward. Thank you.
Thank you, Jared, for explaining how the Department of Justice's involvement influenced the way Portland's new accountability system is implemented. Before we turn to audience questions, are there any brief clarifications or final points any of you would like to make? No? Great. Let's turn to audience questions. Audience members are invited to put questions into the chat, either to individual presenters or in general at any time. We'll try to get as many as possible. I have the first question here, and it is for Dan. Based on historical patterns, how many cases a year do we expect the board will handle each year?
That's a really good question. And when we were looking at the staff and the budget, we sort of roughed out some numbers of how many cases there are, which is not right now, because the number of complaints to IPR has gone down. And surprisingly, it was actually lower in 2020 than the year before that, even though 2020 was the year of the big protests where there were a lot of uses of force. But generally speaking, the numbers are going back up to where they used to be, which is about 400 cases a year. And police officers are allowed to file complaints against other police officers. If they don't want to go through internal affairs, they can go through the system that we are talking about. So that might vary the numbers a little bit. Then there's a whole bunch of those that are going to be dealt with by those parts of the top part of the flow chart I showed you, where some people will want to just talk to the officer or supervisor, and some might be dismissed and some might go to mediation. So we're figuring there'll be probably about 240 cases a year that the board has to adjudicate. And the code that we propose is specifically written that the board can choose whether to hold hearings or not. We're hoping they'll come up with some method where some cases don't have to have a full hearing, which would involve basically presenting evidence from both sides and having a quasi-judicial administrative hearing before the decision gets made. So the rough number is about 240 a year. And when you think about, we're asking 33 people to break down into groups of 5, that's still a rather large caseload for each person over the course of a year. But that's one of the reasons. Another question we get a lot is, why are there so many people? And that's one of the reasons, because there's going to be a lot of work to do.
Thank you. This can go to any one of you. What effect will collective bargaining agreements have on successful implementation? Nobody wants to jump in on that one?
I can give it a shot, although I'm not a labor lawyer. I do know from my experience working this case that collective bargaining rights do have an impact on ultimate discipline and the imposition of discipline. And the United States honors and respects the collective bargaining rights of all employees vis-a-vis management. It's an important part of our democracy. Just like civil rights are there to protect against the tyranny of the majority, I think collective bargaining rights are important process to have. Ultimately, however, from my perspective as a lawyer for the plaintiff in this ongoing saga of the settlement agreement, implementation of the oversight board is a requirement of paragraph 195. It is going to happen. Full implementation under the threat of a court order and enforcement if it doesn't. I don't think ultimately it's going to, collective bargaining rights will derail implementation of the oversight board. I think it may, help define its contours broadly. I think it may, affect individual cases where it's appropriate to, have collective bargaining rights asserted against imposition of a specific type or amount of discipline. But in terms of the overall mechanism of the oversight board, that has now been agreed by, the PPA. The union had an opportunity to object to paragraph 195, and they agreed to it, and the city has agreed to it as well. And so while they go forward and bargain the rights as necessary, I don't think it's ultimately going to derail implementation of the oversight board.
Thank you, Jared. I think Dan wants to add to that a little bit. Yes?
Yeah, well, I do want to add to it. I just want to make clear that We don't know exactly what there's two basic police associations that are affected by this. That's the Portland Police Commanding Officers Association, or PPCOA, and the Portland Police Association, or the PPA. And that's one you hear from most often because you're a lot more of them. The PPCOA is only the lieutenants in the police bureau, and the PPA is the sergeants, detectives, and officers. The charter, the code that was put in the language that was put in the charter when the ballot measure was passed, says that if any part of this design isn't enforceable, the rest of it stays in place. So if it is possible for pieces of this to get broken off or end up in litigation while the rest of it goes into effect, we're hoping that's not what happens. But I think you heard that we talked with the Portland Police Association early on in our deliberations. We requested of one of the city commissioners to ask the PPA to come back and express what concerns they have so we could help design the system to accommodate those concerns. And either that invitation didn't happen or the invitation wasn't taken up on. And then the PPCOA was also invited to speak to us, and it was toward the end of our process, admittedly, but they ended up not appearing in front of the PAC. So we didn't hear from them either what their concerns might be. We hope that we don't get surprised. we hope that they recognize that the will of the people is there for there to be a strong and effective system, and that we went out of our way many times to make sure that this was also fair to the police officers.
Thank you, Dan. This question is for you, May. Please explain how the new system will be different than the current system, the independent police review.
Thanks, Monica. So I'm doing this from memory, so I apologize. I'm sure Dan will correct me if I missed something here. I think two of the biggest differences between the old system and the proposed system are, one, that this will be one community agency and one bureau that is running this process. So in the current system, you have all these stakeholders. You have the Citizen Review Committee, you have the Independent Police Review, you have the Bureau's Internal Affairs Department, and then you also have the Police Review Board. And these cases shuttle back and forth between these different departments. They have different standards of review. So the Police Review Board, for example, uses the preponderance of evidence standard. The Citizen Review Committee uses a reasonable person standard, trying to put themselves in the position of the commanding officer, which can be something of a mental contortion for a civilian to do. So there's a lot of these sort of conflicting or sometimes contradictory systems in play in the current system. The other, I think, biggest differentiator between the current system and the proposed system is that these decisions will be made directly by the new accountability board. And so you will not have a system where we are making a recommendation. We are saying we think this happened and we think that the discipline for this should be X, but we are saying this is the finding of the board. It doesn't filter through the chief or the mayor. And I think this is actually responsive to a frustration that we have heard voiced by members of the Bureau and also by City Council, which is that because they function as the employer in these discussions, right, they often can't say very much about the cases that come to the fore. They can't talk about whether or not they're satisfied with an outcome or with an officer's behavior, because that could be prejudicial, right, for the labor process. And so this new system will decouple that somewhat from the mayor and the police chief in a way that I think is useful and hopefully responsive to some of the frustrations and some of the issues that we've seen with discipline being overturned in the past, because someone said something in passing that was construed as being prejudicial. So I think those are two of the biggest differentiators, but I would invite my fellow commissioners to chime in if I've missed something. Former commissioners.
Commissioner Dan?
Former Commissioner Dan. Thank you.
So used to it.
One of the things we talked a lot about at Portland Cop Watch and in the commission, that's really, really important difference, is that the IPR, currently they can send somebody from their staff out to the scene when there's an officer-involved shooting, which is one of the most serious, if not the most serious kind of potential misconduct that there is. but they're not allowed to do the administrative investigation to see if the officer violated policy. They have to rely on internal affairs. They can oversee that. They can give advice, and they can make sure that the investigation is going a certain way, but they can't do the investigation themselves. And then any other kind of case, from if an officer is rude to you all the way up until they use force that causes an injury, if the community member doesn't like the outcome, they can appeal that finding to the Citizen Review Committee, but not if it's a deadly force case. And what we designed what's in the charter is that the board has authority over deadly force cases. So the board can investigate them. Their investigators can go to the scene and do the investigations themselves without internal affairs involvement. What we wrote into the proposed code is that the community members or their survivors, if it's somebody who was killed by the police, can file an appeal to the board, just like in any other case. And just for historical context, the father of Keaton Otis, who was killed by Portland police in 2010, tried to appeal the findings that there was no misconduct in his son's killing, and he wasn't allowed to do it. So I've always been referring to this as the Fred Bryant Clause. That was Keaton's dad's name, because to honor his efforts to try to do that, and hope that in the future people can try to get justice. Thank you.
Thank you, Dan. This is for Jared. How does a proposed system compare with other jurisdictions with settlement agreements? Are there any aspects you find promising?
Yeah, I appreciate that question. I wish I could give a more a fulsome answer. What I can say is that the hallmarks of any effective police accountability system is the timely, thorough, and fair investigation of complaints of misconduct and the even-handed application of discipline where misconduct is found. I'm not authorized to speak as to other, as to the PAC's proposal. My jurisdiction is going to be to evaluate the city's proposal. This is part of the process, and so I know that the PAC's recommendations will go to City Council. They have gone there, and City Council is going to digest and make the proposal to the United States based on what needs to be in the settlement agreement. I will say that it was a unique process. We have not seen a process like this where a legislative body or a juridical entity like the city has tasked a 20-member commission of volunteers to come up with this type of important structure. It is the Portland way, I think is how we like to say it, and it is unique in a process. It was one that the parties were happy to agree to in terms of the additional new remedies. In paragraph 195, it codifies the PAC's work, it codifies City Council's evaluation and proposal to the United States, and then the parties ultimately will go to the court. There will be another opportunity when the court considers any amendments and whether those are fair, adequate, and reasonable for folks to come and chime in on this sausage making endeavor. But if that's an artful enough dodge, I will let you move on to the next question. I'm sorry, I can't give a more complete answer.
Thank you. This question's for Faith. How do you think the proposed changes will improve transparency and engage with the broader community?
Great question. I didn't say that in my day job, I work on data and transparency and accountability. So it's something that I'm passionate about and was able to serve on the subcommittee when we were determining what measures we would use and make public. And so I think there are a couple of factors that will perhaps be different. So one of them, which I shared earlier around the reporting and transparency, a huge point of access is to be able to see raw data. And of course, we want to protect people's privacy. So those data would be de-identified. We wouldn't have any personal identifiable information in the data. But for any analysts, that's a really best practice, is for someone to be able to download a spreadsheet and be able to look at your findings or your Tableau dashboard and say, oh, this makes sense to me. I can see this in the spreadsheet, or I want to look at it a different way. So that's one of the ways. Another way, I think, is that we have really prioritized community engagement and with staff. So having a community engagement body that would be really a staff person involved in getting people involved in the work. Additionally, having 33 board members, these are folks who live, work, and play in Portland, as the board members will be a critical part of community and telling the story and having lived experience to understand the investigations that they're reviewing, the case files that they're reviewing, bringing news back to their own community members. And then as Dan shared, and you may shared a little bit about a complaint navigator, is that our recommendations, the PAC recommendations, is that our complaint navigators are not necessarily full-time staff, but that they come from community organizations who would be specialized to support in native language or with specific lived experience or context specific. And so I think that there were multiple avenues that we considered ways that this new body could reach the community that we're not doing already.
Thanks, Faith. This one's for Dan. Can you explain how you envision the new board will be involved in Police Bureau policy?
Sure. I mean, I mentioned that a specific case can carry with it a policy problem. I'll give you an example, a real life example that happened probably almost 20 years ago, where there's a person whose car got towed and the police left them by the side of the freeway with no way to get home. So the person filed a complaint, and the oversight body, which I can't even remember if it's the old one or the newer one, made a recommendation on the spot that they should make a policy that if the police can find a way to get the person a ride and it's safe, that they should not leave them by the side of the road. So that's a kind of example that can come from a specific case. So that's one way they can make policy recommendations. And none of us, I guess, addressed that in the charter. It says that the board can make policy recommendations to the chief, and then if the chief doesn't agree to accept them, then it's going to go to the city council, and the city council has to vote on whether or not they support the proposal. That is a new power. Another way it differs from the current system, that right now, if the chief disagrees, basically city council has no say in that, essentially. I mean, they could, but it's not written in the charter that way. Is that helpful? Do you want to hear more? Does the person want to hear more
That's
than that?
great. Thank you, Dan. I'll throw this question out to you, May. What would you say to critics of the proposal who believe that this system will reduce officer morale and make it more difficult to hire qualified and community-oriented officers in Portland?
That's definitely a consideration that I think everyone who was on the Police Accountability Commission, factored into the decisions that they made. Obviously, we do not want to create a system that demoralizes officers, right? And I think I find it sometimes a little defeatist to assume that a robust system of accountability is one that officers will not want to participate in, right? Because that sort of presupposes that officers have something to fear from that system. And I don't know that that's always the case. I think one of the things that we have tried to incorporate is responsiveness to feedback that we got from the PPA and also from officers who have participated in the appeal process, that the current system is confusing not only for community members, but it's also confusing for officers, right? They don't know where their case is at in the appeal process or in the investigation process. Those cases can take a long time. Which often prevents officers from necessarily being back on the street until after everything has gone through. So I think, a lot of this will be in the implementation, and I think it does require buy-in from the Bureau. And I hope that there is an opportunity for that as this proposal works its way through City Council and into implementation. But I think that I would hope that officers would want a system that is just and is fair and addresses community concerns. And I think that we've endeavored to make a system that does that. So hopefully that's a satisfactory answer.
Thank you, Yume. This question is for Faith. Who is the committee processing the applications for the transition team, and who can serve on it?
Yeah, I want to just jump on a little bit from the previous question really quick. I think one of the things, we've heard a lot of potential criticism of more accountability will equal less interest in recruitment for law enforcement. And I think I struggle with that argument because, so as I mentioned, I'm an analyst in my day job, and my work is subject to public records requests or audits. And whenever I know that the auditor is sort of looking into my work, I think, like, bring it on, like, make me be better or help me be more transparent of, I'm a public servant. It is part of my job to be a good steward of public finance. And so if the auditor finds that I have done something wrong, it makes me better at my job. So I think I would invite conversations with police around the same way of, when we talk about accountability, it's being responsible and responsive to community complaints to be better at our jobs, to make the community safer. And so I think that that's one that I really struggle with, and one that I would invite us to be able to have meaningful dialogue around, for sure. The second question around the transition team. So the transition team, and I think that I didn't go into details enough about this, is made up of transition staff. So the proposal included at least 3 members of City of Portland staff who are familiar with the work of the Police Accountability Commission and the work ahead, and then up to 12 volunteers. So those would be the transition team volunteers. And we wrote in the areas of, I think the recommendation states that so City Council would kind of give a thumbs up to the creation of the transition team, and the staff would be appointed. And then the staff would appoint transition team volunteers, and the volunteers would be made up of former PAC members and former or current members of the CRC who are not interested in being on the board, on the new board. And that goes for the same for PAC members. So if any PAC members are interested in being members of the board, they would not be on the transition team. So that's how you get appointed to the transition team, potentially.
Thanks, Faith. This question is for Dan. Is there a statute of limitations on officer misconduct?
Well, I didn't pull the proposed code up, but we did say that complaints had to be filed in a certain time, because as Mr. Hager was talking about, you want to make sure everything's timely and fair and thorough. And one of the complaints we've had from both community members and police officers over the years is that sometimes these things are hanging on over their heads for a long time. At the same time, there are circumstances that might extend those timelines, where, for instance, if the officer's not identified right away, and then it takes a while, and then they ultimately get identified, or if the person is incarcerated and their lawyer says, well, first you got to deal with your criminal problems, and then we'll deal with the complaint. There's provisions to extend the timelines for things like that. So I think the hard outlying number of years was, I don't want to say it into the record without looking at it, but is at least 2 years. It might have been longer than that after the incident happened. So I'll try to look at that during the break. And I just want to also add to this conversation about the officers worried about bias from this new board. The board's decisions have to be sound. They have to be able to make it through all these appeal systems that the PAC can't get rid of. They have to be able to go through the Civil Service Board. They have to be able to go through the arbitrators. And if it doesn't stand up in those other forums, then the board's going to have to go back to the beginning. And even if they begin trying to do things that don't rolled up in those forms, eventually they'll learn that that's not the way to do it. But I think the better thing to ensure, I'm hoping to ensure the public, is that they're going to be trained in all this, they're going to have to understand all this, and that, you know, by design, they're going to have to be fair and reasonable when they're making their decisions, so that it will hold up in these other venues. So I'm hoping that is helpful to folks. Thanks.
Thanks, Dan. This question's for you, May. How can the new board ensure Portland city attorneys do not interfere with the new board's ability to investigate officer misconduct?
That might actually be a question for Dan, I think, just because I'm not familiar with I think the case that prompted this question.
Dan, would you like to take this one?
Well, I don't know what case prompted the question, but the charter, again, the charter says that this board has independence and it cannot have interference from other parts of the city government. That in theory, they're going to have their own attorney or attorneys plural to advise them, because one of the problems with the current system is that the same city attorney's office that defends the city and says, oh, in cases of a lawsuit, the officer did nothing wrong, or else we'll have to pay out millions of dollars, are the same city attorneys who advise the Citizen Review Committee and the IPR when they're trying to decide whether or not there was misconduct. And there's an inherent conflict in that, right? So, so I think that the charter language is pretty clear that the city attorney can't really interfere with the independent decision-making of the board. The exact mechanism for that, I don't know exactly what it's going to look like, but that's what it says in the charter.
Yume, I'll throw one to you. Will Portland Police Bureau's Internal Affairs Division be dissolved?
Our proposal does not make a specific recommendation to that effect. What the code package proposes is that the handling of officer-involved shootings and complaints involving members of the community will be handled not by internal affairs, but by the new board. We intentionally left it up to the Bureau to decide how they want to handle internal complaints that exclusively involve officers that the officers do not choose to appeal or bring to the new board. So it is possible that internal affairs, they'll have less to do, I think is the short answer. But it is presumably they have the option and will likely continue investigating things that are internal to the Bureau. So maybe issues of truthfulness that are internal to the Bureau, issues of officer courtesy between Bureau employees, which is if you read the Police Review Board summaries, that's a pretty common complaint is, maybe an officer had a dispute with another Bureau employee, a criminalist or a records clerk or something of that nature. I think that could also incorporate things like traffic accidents if they didn't involve a member of the community. So there are definitely things that would likely remain within IA's purview, but that will ultimately be up to the Bureau and the city attorney.
Okay, this question will go to Faith. Are there national best practices that guided development of the ballot measure and implementation code?
Yes, great question. I don't mean to be a plug for our own work, but we have many a page written around some of those best practices that we identified around the country, and then by academic and researchers and think tanks who work specifically on this area. I know I can't speak for the folks who developed the charter, but I know that one area that one organization that we really looked at was NACOL, National Association for Dan.
Community
Civilian Oversight of Law Enforcement.
There you go.
Thank you. So, so I'm happy to put in the chat in a little bit. We have two major documents that look through, or one major document that looks through the research of jurisdictions and cities and areas that have implemented similar community-led police oversight bodies. And then also what experts are saying around best practices. And I think I'm sure many of you will want to read our 503-page document, And throughout it, we have cited where that recommendation came from. So when you look through, particularly in the back, there's areas of agreement. So those are where more robust language are found, and you can find this recommendation came from Chicago or from Seattle or from Oakland. So we really spent a good 5 months of our 18 months researching on what best practices were that we could look to develop our model.
Thank you, Faith. That was arduous work, you guys. That was many hours. Anyway, Dan, can officer misconduct, which was previously swept under the carpet, be refiled with the new board?
That, I don't know if we contemplated that. I mean, it does seem like we give the chance for dismissed cases to be appealed, but I don't know whether that would apply to things that were dismissed under the old system, you know? Maybe we need to go back and rewrite our plan. Oh, it's too late. But I think that would be, I think it would be a good idea. I think it would be a good idea to give that ability for, because as I said, we're trying to level the playing field so that people who were not given satisfaction under the old system would be able to come to this system, or who are even dismissed by this own system, that they can have several venues of appeal. So that's something to look at. I want to add, though, I did look at the code, and I put something in the chat that I found in our proposed code 35D070 subsection B that says if the timeline is extended for reasons listed in the code, it may be extended to a maximum of 5 years. So actually, I was underestimating how long we gave that.
Faith, were you going to say something?
Well, thank you. Kim just put it in the chat, but we didn't speculate that scenario specifically, but you can see in the last section that was written was an exemption for good cause. So there is a 12-month statute of limitations, but with an exemption for good cause. And we outlined good cause as, so may include but not limited to fear of retaliation, if an officer who was not previously identified had their identity become known after the 12-month deadline.
Thank you. Jared, this question is for you. Please explain what a fairness hearing is. Can anyone speak at that hearing?
Yeah, thank you for the question, and it's a good one. We are destined for a fairness hearing whenever there's a proposed amendment to the settlement agreement, because it is a federal court order. A fairness hearing is a hearing of the court at which the parties would present and give the reasons or the arguments for why a proposed change to the federal court order, the settlement agreement in this case, is a good thing, is a reasonable thing, is an adequate thing. And then the court cannot approve the amendment until it determines that the change is fair, adequate, and reasonable. At a fairness hearing, historically, in this case, Judge Simon has opened the courtroom to anyone who wants to come testify. It's not a sworn testimony. It's more like coming up and giving a statement, kind of like you might do at city council. The court will accept not just oral statements, but you can submit statements in writing. You can video record and submit those. We've had all manner of community participation. We've had organizations participate, and of course the parties, including the union, the Albina Ministerial Alliance Coalition for Justice and Police Reform, and the Mental Health Alliance. So in addition to those groups, the floor will be open, a microphone will be available, there will be a sign-up sheet. When that time comes, and we're looking down the road a few months, I'm happy to let people remind people of what that fairness hearing is. It's basically an open court proceeding at which anyone in this courtroom before this judge would be allowed to give their opinion.
Thank you. It looks like we have 4 minutes. So, and I have 3 final questions here. I'm going to just pick one and see where that leaves us at. How will changes to the city council structure impact the implementation? Is somebody dying to take that question? I can't see Yume right now. I don't know if he's happy to answer that question or not.
I can definitely try. I
All
think
right.
I think the answer is yes, just in the sense that it's a new system of government and city council will be responsible for implementing anything that this current council does not finalize before they leave office. That council will also be responsible for potentially choosing future board members, right? So that being said, most of this has already been proposed, will definitely have been voted on by this current city council. And so I think the structure should remain roughly the same, right? There will be some, as with any transition, there will be some tweaks to be made or some things that maybe were not contemplated when we started this process 18 months ago. But ultimately, council is primarily tasked with implementing the current code, which will fall to this council, and then tasked with filling vacancies on the board, which I imagine will look somewhat similar with 4 commissioners or with 12.
And I'd just like to add, the settlement agreement does contemplate changes in city bodies and city structures, and it obligates, future restructured entities in the same respect as the old entities. And so from my perspective, as a plaintiff United States in this ongoing matter for police reform, I don't have any worry that the change in structure will somehow prevent the full implementation of the oversight board. The city as an entity has agreed to fully implement the new community police oversight board in paragraph 195, and whether it is a single mayor with 12 council members or a 5 council structure, that is an obligation that the city has agreed to in federal court.
Thank you so much. I don't think we have time for any more questions. Carolyn?
Thank you, Monica, for moderating. And thank you, Faith and Yume and Dan and Jared for your perspectives. I'm glad this is recorded because I think I'm going to have to listen to it again. It's a complicated subject. And I also want to thank the other 16 members of the Police Accountability Commission for your thousands of hours of work, including thanking our own member, Debbie Iona, who was on the commission. So, and by the way, thank you for those who listened and sent in questions. I also want to thank Metro East Community Media for recording this program. The video and the podcast will be available in a few days, and you can get the links from our website at www.lwvpdx.org. We hope you'll join us for our next program, which is November 15th. It's on the challenges facing the transportation sector in Portland. The League of Women Voters is a membership organization. We thank our members for their generous time of volunteering of their time and their financial support for these programs. We welcome you to join the League. This program also was supported by our Education Fund and the Carol and Velma Sailing Foundation. You'll find membership and donor information at our website, www.lwvpdx.org. Good night.